So this is the next part of my series on what's changed in the judicial system since I started practicing 50 years ago. One of the major changes is the judicial attitude toward jury trials. I remember when I started out, I used to have at least 2 jury trials a month. I haven't had a jury trial in years and decades almost. I used to have preliminary hearings of one or two a week, and you don't have those anymore. About the time Nixon got elected, maybe just a little bit before, there was the movement to restrict the purview of the jurors. And the folk knowledge or opinion at that time was the jury was to determine facts and the judge was to determine law. Well, this was absolute bullshit, but most of the people went along with it because they didn't understand juries and didn't understand what they were and how they functioned. What the jury does is much more than determine facts. It determines the facts, the fairness, the application of the law, whether the law is fair, whether the law isn't fair, how should it affect people and how should it not affect people. So, if the law is particularly onerous, the jury can say, screw that, I'm not going to convict. Or if they don't think the person deserves to be tagged with such and such a label, they'll acquit. Or they might modify. But as long as you have a judge saying, this is the law, take it or leave it, and determine whether this is a fact or that is a fact or something else is a fact, then what you have is dictatorial rubber stamping of the executive decision, which in the court system is generally the police department. So a policeman can say, well, I think this is assault on an officer. Well, you have a certain definition of assault. Was the officer struck or whatever? And if you determine that as a fact, he's found guilty. Well, then you can get a chicken shit hard ass judge and say, okay, you shouldn't assault police officers. I'm sentencing you to 20 years in prison. Or you can find some other thing where the guy might even get 2 years in prison or even probation. So one of the things that defense attorneys used to do was act as an advocate for the defendant. There were lots of factors that mitigated things or aggravated things, and we were the person that explained that to juries and judges. Our job was to look for good in people and convey that to our audience, whomever that may be. So most of the time, I took the attitude that there's good in everyone, and my job is to point it out and go from there. I remember one case that Judge Kane was said or called a chicken shit case with no dignity was my client Joe Griola, who had 2 prior felonies, and they set him up on a sting operation. After he just got out of jail, he couldn't get a job, and these guys in the sting operation owned the bar, and he begged them for 6 months to give him a job cooking. He was a real good cook, actually, and they wouldn't. They kept saying, oh, Joe, you're made for better things. You'd go out and steal some securities or whatever. And then the cocktail waitress or the waitress at the bar moved in with him, and she was working off a debt to her boyfriend. Her boyfriend had been busted on a drug case, and she was encouraged or recruited to entrap somebody so that her boyfriend would get a more lenient sentence. And Joe was elected to that. So in any event, the judge in that case was so outraged over the circumstances that he put Mr. Briola on probation, which was real curious. It was the first time he'd ever got a break. He opened up a restaurant, and both the people in the neighborhood, many of whom were criminals, and the feds came there for lunch and things like that. And they got to know each other, and there wasn't any problem with Mr. Briola after that, which was kind of an interesting thing. He became a project, and a project for leniency. And he did travel interstate with some stolen securities and tried to use them to get into a gambling game in California. And the game was raided, and they found the securities and tied the securities in with Mr. Briola, and that was that. And the securities were given him by the FBI agents. So it was a clear-cut case of entrapment. But again, juries would view that differently than non-juries. Juries generally have a little sympathy. The recruiting situation for district or for judges nowadays generally comes from the district attorney's office, and the district attorney's office has a particular bias. They view everybody as the enemy generally, and their job is to make America safe, make the streets safe, as though they weren't safe before. And therefore, if a person does this, that's a crime, and he's supposed to get that. And that was reinforced actually by the sentencing guidelines, which essentially put all the defense attorneys out of work, turned us into rubber stamp whores also. Unfortunately, a lot of my colleagues acquiesced to that for economic reasons and because they really didn't have much ideological backbone. But again, that's part of the reason we have change that we do have right today. Efficiency and fairness or democracy are mutually exclusive terms. So when you have a big push to get more cases through the court system, how do you make it more efficient? Well, you rubber stamp the cases. You abolish jury trials, and if that isn't fast enough, what the next thing they did is they sort of abolished the rules of evidence, making it easier. Thirdly, what they did in the 70s was change the requirement of intent. Under common law, a crime was something committed by a bad guy. And there were three defenses. You didn't do it. You did it, but it wasn't illegal. Or you did it and the devil made you do it, which was a variation they called insanity back then. So you have all kinds of reasons people commit crimes. Now, as we shifted to Napoleonic law, I often use this example in my classrooms. The perfect distinction between common law based on equitable and religious principles and Napoleonic code based on Roman law is the basis of intent. If you take Les Miserables, the protagonitor there stole some bread from a bakery window. Why did he steal the bread? Well, under the Napoleonic Code, it didn't matter. He stole the bread, therefore he's a thief. Now, he stole the bread because his nieces and nephews were starving, and he had to support them. And there was a reason for doing it. Necessity. Under common law, necessity was a defense. You might get sued for the value of the bread, but it didn't make you a criminal. So that's a big difference between common law and civil law. In Napoleonic civil law, the motive or whatever doesn't matter. Now that has all kinds of serious ramifications on society. because it negates the concept of redemption. It negates the concept of innocent until proven guilty. It negates several theories that we have been indoctrinated with in our Judeo-Christian background. So you do the act, and the act's a crime, you're guilty of the crime, and you're punished there accordingly. Now, if you recall in the Miserables, the guy got what they called institutionalized, Jean Valjean did. And to exist in prison, he had to adapt to the prison mores, folkways, and culture. So he had to toughen up and be wary in order to survive. So finally he gets out. And of course, the inquisitor, Gilbert, hounds him for the rest of his life, because under Napoleonic law, you're labeled as a criminal, and once a criminal, always a criminal. So they just watch and wait for you to do something bad so they can justify their pre-existing opinion. So this was pretty much reflected in the first incidents when Valjean got let out of prison. He stole something from a kid. He went to a church for food and shelter, and on the way out of the church, he stole their silver. Now, you had a priest representing the Christian doctrine and the Napoleonic policeman representing the Roman law, and they arrested Valjean for stealing his silver from the church. And as the arrest was going down, the priest, whose action was based upon Christian charity and Christian beliefs, took 2 candlesticks and gave it to Valjean and said, "Here, you forgot these when you left," explaining that they gave him the silver in order that he could make a new start in the world, which he did. And the rest of the story dealt with his redemption and what he did to redeem himself, and the labeling theory, as criminologists would say, from the Napoleonic principle that once a thief, always a thief, and the two systems could not be reconciled. And if you notice the end, the police magistrate or police, procurator, whatever the hell they call him, jumped off a bridge because he could not intellectually and in good conscience reconcile the label of once a criminal, always a criminal, and what he'd observed from Jean Valjean during the time that he bugged him all the time. So that is one of the main differences. And what we did in this country is we abolished the concept of jury as such, and we got into an inquisition or an inquisitory system where we inquired, and the juries that we have now rubber stamps the facts if the facts are proven, and the judge takes it from there and determines that a person's a bad guy and punishes him consequently. This was going on with many other things. Another thing they did was change the rules of evidence to make it easier to prove. But the main thing with abolishing jury was also changing the concept of intent. So I'll give you one example here before I close. There are different degrees of homicide. Homicide is when somebody dies. So I can be sitting or standing or whatever in front of my class and lecturing, and I might just gesticulate. So I've got this in my hand, And I'm doing this, and I'm gesturing, and almost like conducting the class. And all of a sudden, it goes out of my hand and hits a student in the eye. That is an assault. So, under Napoleonic law, it would be a crime. I didn't intend for it to fly out, it was accidental. But under Napoleon, that's just tough shit. Now let's take the same conduct. And I'm looking at this student, and this student pissed me off, and I threw it at him, hitting in the eye. I intended to throw him at it. I knew I was throwing at it. Well, that was intent. I intend to throw it. It was general intent, what we've got now. Under common law, it had to be a little more strict than that. In order to be convicted of a crime under common law, I had to throw this with the intent of hurting this student, causing this student harm. It couldn't have been just from frustration or any number of things. I had to say, okay, I don't like that son of a bitch, and he won't shut up, and I'm going to hurt him so he learns to shut up. Now, maybe I aimed for his mouth and hit his eye or something, but that doesn't matter. I intended to hurt him. Not that I intended to throw the ruler, but I intended to cause harm, and that's the difference. Under Napoleonic Code, you intend to do the act. Under common law, which we no longer have, you have to intend to cause harm. And that's enough for the day. I hope you guys enjoy